Welcome, and thank you so much for joining us today. Today we are sharing with you HR 101 Essentials for Managing Your Workforce, and we are excited to talk to you about all the great things that are basics that your companies need to know. I'm Britenae Pierce, chair of our Ryan Swanson's Employment Rights and Benefits and Labor Group. And today I'm excited to be joined by my colleagues, Kristen Neely-Meyer, Hannah Kern, and Madison Burke. For those of you who aren't already familiar with our firm, Ryan Swanson is a full-service 40-attorney law firm based right here in the Northwest. Each one of us here today are members of the firm's employment group, and we have a bigger group as well. We work with businesses and owners and HR professionals regularly at all levels to help them implement practical, creative solutions to protect their businesses from potential threats that can disrupt their workforce or business operations. Presentation slides are posted on our website as well, so please feel free to go to ryanswansonlaw.com/events to download them. Wage and hour, gosh, this kind of builds on what Madison was talking about in terms of requirements and what you need to do for various employees. And here is what it is overall. So what are these wage and hour laws? So basically, it's anything that governs, any laws that govern basically the hours that are worked, the overtime worked, minimum wage, all of those types of things you see here. So the one thing I'm not going to go into today is child labor, just because that only affects kind of a subset of folks. I'm happy to help on that later, but we're going to focus on minimum wage, overtime, meal and rest periods. And at the end, I have some slides about payroll deductions as well, which I don't know if we're going to get to all of those, but I want to make sure you have that information to the extent that you need it and those questions come up, because those questions pretty much always come up. Okay, what happens if you don't follow these? Much like Madison was talking about, the penalties can be terrible. So, $4 signs, that indicates it's expensive, and it really can be. So when you're audited, when you're investigated, and you're found to be liable, you will be found, for example, to be liable for someone that you didn't pay overtime for and were supposed to, for all of that overtime. And the look back period is for 3 years. So that means that you can be liable for overtime for 3 years. There's also penalties involved. And really, this is where you see a lot of employers just super cringing, is the class action lawsuit that you've misclassified and you should have been considering these workers to be non-exempt employees and entitled to all of these benefits and protections of these wage and hour laws, and you didn't do that. And so you're going to be liable not just for that one employee, but for an entire class of employees. So this is why we really urge you to get it right at the outset. So just like Madison was talking about, how do you classify? How do you, determine if someone is first an independent contractor or an employee? And then from there, is your employee exempt or non-exempt? This is why it's important. And this is, the laws apply to non-exempt, as I'm going to talk about here. And that is your biggest bucket of workers. So just like she said, hey, default is always going to be employee. Absolutely true. Your default is always going to be non-exempt employees. And here's a little visual that hopefully helps break it down. So you've got an entire category of workers. So, anyone who's working for you. And again, you split them into your independent contractors and your employees. And your employees are then either exempt or non-exempt. And Madison went over some of those tests to see whether you can be exempt or whether your workers can be exempt. And those rules are changing. Well, they've recently changed, and I think they'll continue to change over time. And so you've always got to be really careful about that. And often what we see is legislation is enacted to make even more employees in the bucket of non-exempt. So that makes this even more important that you're applying these wage and hour laws, because that circle, that non-exempt category, is exactly who these laws apply to. Let's talk minimum wage. What is it these days? Hopefully everyone knows, but it's not enough to look at federal or not even our state, because it really gets down by city beyond that. And again, this is something that will change in the future. We expect to see more and more cities and these laws getting more localized. So please make sure you're looking out for whatever rules and laws are coming up, and particularly with regard to minimum wage. So you'll see here, Washington does have $13.69 an hour. And then Seattle has its own minimum wage, and it's divided by large and small workers. Small is relative here. It's employees of 500 or less, employers with 500 or less. And the threshold is 1669 if you're a larger employer. And for the smaller employers, it's also 1669 unless you are contributing at least $1.69 per hour to employee medical benefits, or they earn that amount in reported tips, in which case you can reduce the minimum wage to 15. So you really do have to take a close look at that, see what you're doing in Seattle, and make sure that you're complying with that minimum wage. And I put CTAC on there as well, just so everyone is aware. Okay, what are the basic overtime rules? I think a lot of people get this one confused and think, okay, I've worked more than 8 hours a day, so I get overtime. That's not the test. The test here looks at an entire work week. And so what you do is you have a normal 7-day work week. Your 7-day work week can't fluctuate. It's not like one week you pick Monday to Sunday, the next week you pick Saturday, to Friday. So it needs to be your standard work week that you use for your company. You consider that same work week. And within that work week, how much did the employee work? If it's more than 40 hours, they get overtime. Overtime is at a rate of 1.5 times the employee's regular rate of pay. And I'll talk about that in a second, how you calculate that. But employees are entitled to overtime, and you don't get to escape that obligation. They can't say, oh no, I don't want, you'd have to pay for overtime. I'm happy to work the extra hours and you don't have to pay me. They can't do that. And you can't then not pay them. Remember at the beginning when I said, hey, the look back, 3 years, you could be obligated for overtime. This is exactly what I'm talking about. Even if you have an employee that agrees and tries to not worry about it, you can be on the hook. What if things go south? You do not want that to happen. So make sure you're upfront and paying overtime as it is needing to be paid throughout the employment relationship. Now you can require overtime. So there are some exceptions to this, and these are pretty recent for registered nurses and LPNs as well. But in general, you can require people to work overtime. It's part of your right as hiring people and employing them. You should be reasonable about it. You should be appropriate about how you have different people do it, but it is okay as long as you are paying them. And again, beyond the RNs and LPNs, there are some certain specific exemptions or alternatives for overtime. I won't go into all these just because there are so many and they're detailed and nuanced, but if you have a position where someone's required to sleep at the job site, things like that. So if you've got a little bit more of a unique situation, it's worth looking into whether there is an alternative or an exemption for overtime. But aside from that, the vast majority of companies, the vast majority of employees have these overtime obligations, and so you should be meeting those. Okay, I mentioned that regular rate of pay. That is not just what someone's hourly rate is, although that would be much easier to calculate. It's just not that simple. So what it is, it's their hourly rate or base pay, plus commissions, plus these non-discretionary bonuses or rewards or things like that. So if you have like attendance rewards, if you've got non-discretionary bonuses, sometimes people have them for how long someone's been employed, something like that. All of that is calculated into the regular rate of pay. Commissions are included as well. So the point is you don't want to shortchange your employees by only giving them, the overtime of their hourly rate, which is again 1.5 times, but you really want to take into consideration what's the total amount they'd be getting and make sure you use that as their regular rate of pay for that time period. There's a different calculation for piece rate workers. Again, this doesn't come up all that often. It does sometimes. So just wanted to make sure you're aware of how you calculate for non-agricultural piece rate workers. And so I've got that there as well. Oh, this one, you guys, this one has really come up more and more with COVID, working from home. What do you do about that off the clock work? And I mentioned that a little bit before, but basically, does the employee need to be paid for off the clock work? Off the clock work is generally, those emails you send early in the morning or late at night, or you show up to the office early and you start work before your scheduled start time or before you clock in, or things like that. Yes is the answer. I should have put that in like big bold with a megaphone like Madison had, because it is very important that you are paying your employees for off the clock work. It can be, regular time. Let's say they work a 30-hour week and they do some additional hours that's supposed to be off the clock. That might not be overtime. But if they're already working 40 hours a week and then they're doing this additional time that they're actually working, that will be considered overtime, and they will need to be paid that overtime rate for those extra hours. So what do you do about this? You can have a policy. In fact, you should have a policy saying, employees, you are not allowed to work off the clock. You are, whether you time card or not, you work when you are in the office, or you work for these set hours, and we do not agree to let you work off the clock. And you can have them sign off on their time cards. It's more and more electronic, but you can certainly have them, sign off and certify that what they have submitted as their time records are true and correct, and they swear it is. So keep that in mind as something you want to do. But what if they do it anyway? Do you still have to pay them? Yes, you do. But you can also potentially discipline them if you need to do so. It's not the first step you should jump to. You should certainly talk to them about it at first. Tell them the employee can't be working off the clock, explain why, say you need to pay them, you have not authorized this overtime. And ultimately, if they keep doing it, you can discipline them for that. So keep that in mind if you've got employees that you think are working off the clock. Okay, rest breaks. These are paid rest breaks. So these are the things when you're, this happens more, I guess, maybe at the office, but sometimes at home, you grab a personal call, you run, go get a glass of water, you take a break, you walk around, just one little loop around the block or whatever it may be. These are important for workers. So, they're not slaving away with no breaks. So they are paid, they are not waivable, and they are entitled to 10 minutes for every 4 hours worked. And I've got a little chart there that shows you kind of what that breaks into. So, if they only work 3 hours or less, less than 3 hours, then they don't need a break. But if they work between 3 and 7 hours, they get a 10-minute break. More than 7 hours, they get 2 10-minute breaks. This is in addition to the meal periods I'm going to talk about in a second. Mini breaks can be okay. Back in the day, I think more people consider these smoke breaks, quick grab your cigarette. I don't think that's quite as popular now, but mini breaks certainly still happen, and those can be okay as well. So it doesn't have to be in one set 10-minute chunk of time. Again, important note for employers is to be paying for this time. Again, I've got a note about piece rate workers up there. So you also have to pay their rest periods in addition to piece rates. There's additional requirements for healthcare workers. And so if you've got healthcare workers, there are some new rules related to that. And so you'll need to look into those, but I've got a note on that there as well. And pregnant women and nursing mothers. So they may be entitled to additional rest breaks. There are, a number of different considerations with respect to this. So if you've got an employee who's pregnant or nursing, definitely, be lenient in what they're entitled to for rest breaks. And, it's too detailed to go into here. We can gladly follow up on that. But basically, especially for nursing mothers, you need to provide them breaks to nurse up to a year after the child is born. Pregnant women may need longer breaks or more frequent restroom breaks, those types of things. So keep those in mind if you've got an employee that's in this category, that you might have some additional requirements there. Okay, meal breaks. What are meal breaks about? So these are, again, in addition to the rest periods, and these are 30 minutes when working a 5 or more hour shift. This can be unpaid if your employee is not working and is free from all duties during that time. But let's say you have someone at reception where they have to answer the phone or they're sending emails, that they're not free from duties, and then that must be paid. So you need to really determine, are they free from all duties or not? And then do you pay them or not? But they are entitled to this 30 minutes. But what happens when the employee wants to waive this meal break? And a lot of employees actually do. So if they want to waive their meal periods, they can do that if the employer agrees. And the employer doesn't have to agree. And so keep that in mind, that you don't have to if you really want your employees to be taking breaks. But if you do agree, then it should be in writing. It should be signed by the employee saying they are waiving this right they have to their meals or their meal breaks. Okay, I did put on here, as I told you, about deductions, and I am going to go into that a little bit. I've got a few minutes more, so I want to make sure I'm covering some of that for you guys. So paycheck deductions are tricky. And I think every time companies consider a paycheck deduction, it's worthwhile to go back and look at the laws related to these. And actually, Washington's L&I website has a pretty good page that kind of walks you through the steps. I would say every time you really should be walking through the steps and not just relying on what you think is okay, because it's different for workers that are currently employed, for what the deduction is for, or if it's for a final paycheck. And so there are certainly different requirements you want to pay attention to. This slide here is talking about, can you deduct from an employee's paycheck advances? And yes, you can if you meet these certain requirements. So really it has to be for the employee's benefit. This isn't a way for the business to be making money. So let's say you have agreed to advance the employee some money and you have, some small amount of interest, it has to be some very small business related interest. It's not like a penalty related to it. Then yes, that's okay. But you need to have a written agreement in advance. This is not some off the cuff, sure, we'll agree to do this, and then later you try to deduct. You need to have this set up and you need to have the employee's agreement. And this deduction, this type of deduction, it can be while the employee is employed, or it can be from the final paycheck. But this is important. In this instance, you can reduce below the minimum wage. And some of the other instances we're talking about, you cannot reduce below the minimum wage. So really do be careful about that. And the reason this one can reduce below the minimum wage is because the advance is for the employee's benefit, which is a distinction there. Okay, what about final paychecks? Now, again, the parties need to agree to this. While technically an oral agreement is okay, that just makes me cringe. I really want you to have a written agreement to protect you. So you want a written agreement that says, okay, we will agree to this deduction from the final paycheck. Now, here are some other things that you can deduct for. And this comes up a lot, that someone's like, oh, someone shorted the till or they broke something. You just can't automatically deduct in those circumstances. So I've laid out here some of those circumstances for you. And for example, if you have a theft, you just don't get to automatically deduct, but you need to file a police report. If there's some sort of loss or damage or something like that, again, that has to be caused by some sort of dishonest or willful act, not just, hey, I knocked the lamp over on my way out the door. And in this instance, you cannot reduce the check below minimum wage. And this is not waivable. So please do keep that in mind as well. Okay, what about other agreements between the company and the employee? So basically, if it's for the personal benefit of the worker, yes, you can reduce below minimum wage. But if it's for the business's benefit, then you still need to meet the minimum wage. So gosh, even in those few examples, you heard me go back and forth. Here you can go minimum wage, below, here you can't. This is why it's a pretty tricky area and why I strongly encourage you to make sure that you are looking at these laws anytime you want to have a deduction. We're happy to walk you through that, but it is important that you make sure you do not err on the wrong side, because circling back to where we were at the beginning, if you aren't meeting that minimum wage, if you aren't paying your non-exempt employees what you need to be paying them, then you certainly can have penalties and liability, and we all want you to avoid that. So